Roger Alford here as our lunch speaker. As you probably all know, until a few weeks ago, Roger was the Principal Deputy Assistant Attorney General for Antitrust at DOJ, the number 2 official in the Antitrust Division, and he also served as a Deputy Assistant Attorney General in the first Trump administration. He has returned to his position as Professor of Law at the Notre Dame Law School, and the topic of his talk today is the rule of law versus the rule of lobbyists, which presumably will talk about his recent government experience, and we're really delighted that he's using the platform here at TPI to talk about this very important issue. He actually also has a prepared text which will be sent to everybody at the conference, or at least available on the website. But I think it's going to be sent to everybody. So, with that, Roger. Go.
Thank you very, very much for the opportunity to be here. It's been an interesting month for me. I sold my house on July 8th, excited about my stint at the DOJ, and then found out a few weeks later that I was not going to be at the DOJ. So I've been homeless and jobless, for the past few days, and Notre Dame has been absolutely amazing in welcoming me back. I wanted to speak here at TPI instead of accept invitations in the rush at the end of July, early August, because I wanted to be really careful and thoughtful about what I wanted to say. I didn't want to, I'm not on Twitter, and I'm not I don't want to just think from off the cuff. I wanted to be very careful in my remarks. So the comments I say today are very careful, but they're very pointed, and they're very pointed at specific people. And the reason that they are is because I don't view this as a systemic problem. I view this as a personnel problem. And if we can make a few key corrections, then I think we can be on the right path. So I'm going to give you my prepared remarks because I think it's important that I be careful. So thank you for the opportunity to be here today. I truly am honored. I've been here before in the past, but it's great to speak here under these circumstances. I've served in and out of government for the past decade, and I've noticed something ironic. As a law professor, I have so much to say, but so few that are eager to listen. But as a senior government official, I have many who are eager to listen, but there is so little that I'm allowed to say. So today I'm fortunate because as a law professor and recent senior government official, I have so much to say, but also so many who are eager to listen. I'm here today as someone who is happy and grateful and hopeful that in the wake of the HPE-Juniper merger scandal, and it is a scandal, the Department of Justice may course correct with a few policy and personnel changes. Although challenging, I loved my time at the Department of Justice, both the first time and the second time. And I liked it especially as the second highest official in the Antitrust Division working with Gail Slater. But I'll be honest, I love my time better being back home at Notre Dame. It feels a little bit like I returned to the Shire after battling the orcs in the Battle of Helm's Deep. I want to speak with you today about the battle within the Trump Republican Party over the future of the second Trump administration. I'm talking about the battle between what I call genuine MAGA reformers and what I will label, I hope this catches on, the MAGA in name only lobbyists. It's a fight over whether Americans will have equal justice under law or whether preferential access to our justice system is for sale to the wealthy and to the well-connected. Will America be governed by the rule of law or the rule of lobbyists? For the words equal justice under law to be more than just a phrase etched in marble, it must be practiced by those privileged to enforce it. Attorney General Pam Bondi testified just a few months ago about this in her confirmation hearing, quote, "If confirmed, I will work to restore confidence and integrity to the Department of Justice. America must have one tier of justice for all, close quote. The true MAGA Republicans know that we cannot restore integrity and protect the interests of the average American by allowing the wealthy and powerful corporations to hire politically connected lobbyists to receive special treatment. Officials like my boss, Assistant Attorney General Gail Slater, and so many others are working hard to remain true to President Trump's core message that resonated so well with working class Americans. Antitrust enforcement that applies equal justice under the law can prove that the DOJ is not for sale and deliver tangible results for millions of Americans. As I said in my Senate Judiciary testimony last December, we are committed to, quote, common sense populism that seeks to make housing more affordable, reduce the cost of higher education, promote choice and competition in healthcare, and adopt economic policies that drive down the cost of living and prices for everyday goods and services. The MAGA in name only lobbyists and DOJ officials enabling them are pursuing a different agenda. Their loyalty is not to the president's antitrust agenda or to rebuild confidence and integrity in the DOJ. Regardless of the outcome, their commitment is to exert and expand their influence and enrich themselves as long as their friends and supplicants are in power. If the rule of lobbyists prevails, the Republican vision of a realignment toward the average American will die. The current front in this battle is being fought within the Department of Justice. It will not surprise you when I say that AAG Slater and Deputies Mark Hamer, Dina Calais, Bill Rinner, and Chetan Sangvi have been wonderful colleagues, and we are united in the battle to protect the average American by vigorously enforcing the antitrust laws. The same cannot be said of some senior leadership above and around her. Similar to my mentor, James Buckley, who I clerked for on the DC Circuit, in his call for Richard Nixon to resign in March of 1974, I today am speaking out reluctantly as a friend, because I know that what I have to say will bring pain and distress to many people that I respect. I'm asking for statesmanship and courage by senior government officials to promote this administration's antitrust agenda, restore integrity to the DOJ, and serve the greater interests of the nation. I'm speaking out now, early, because it is still early days in the administration. And I think correcting the problems at the DOJ are still possible, either by political will or judicial decree. I experienced nothing remotely like this when I served at the DOJ the last time. And hopefully, this is a short-term aberration. To be clear, I have absolutely no reason to think that the White House or other departments are involved in the current HP Juniper merger scandal. Nor do I think Deputy Attorney General Todd Blanche is involved. But I cannot say the same about a small set of actors in senior leadership within the Department of Justice. I met with the most senior officials of the DOJ regularly, and my concerns expressed today are not based on conjecture. The core problem is simple. Attorney General Bondi has delegated her authority to leaders like her Chief of Staff, Chad Mizell, and Associate Attorney General nominee Stanley Woodward, who do not share her commitment to the rule of law and to one tier of justice for all. With the DOJ led by a mix of officials with varying commitments to restore integrity to the Department of Justice, good may yet prevail. I hope it does. But at least with respect to senior DOJ oversight of antitrust enforcement, we are on a path toward injustice. Let me discuss the battle lines that have been drawn between the true MAGA Republicans and the MAGA in name only lobbyists, and offer just a few reflections on the difference between the rule of law and the rule of lobbyists. First, under the rule of law, rules matter and must be respected both in substance and in procedure. Sir Thomas More, in A Man for All Seasons, put it this way in his famous quote, quote, "This country is planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down, do you really think that you could stand upright in the winds that would blow then? Yes, I would give the devil the benefit of the law for my own safety's sake." Now, if you watched the movie or read the play, when Thomas More explained to Richard Rich why he could not accept even a small bribe such as a silver cup, he said, "With real power there will be offers of all sorts of things, homes, manors, coats of arms." Fill in the blank what that would be today. Only those with principles strong enough to reject the little temptations are worthy to serve in senior government, where there will be offers of big temptations. Under the rule of lobbyists, antitrust laws are nuisances or obstacles to be overcome, rather than the legitimate lobbyists who have expertise and perform traditional functions of education and engagement. I'm not criticizing all lobbyists by any stretch. Corrupt lobbyists with no relevant expertise are perverting actual law enforcement through money, power, relationships, and influence. In A Man for All Seasons, Thomas Cromwell beckoned Richard Rich to betray Sir Thomas More in exchange for a bribe. Rich did so and immediately felt guilty. Cromwell reassured Rich that while Sir Thomas More is a man of incorruptible principle, Rich has common sense, and accepting bribes gets easier with time. The corrupt Richard Rich rose to the heights of power at the end of the play, while the principled Thomas More resigned and was imprisoned and martyred for insubordination. There are people within the DOJ who follow the law and care deeply about protecting Americans from anti-competitive behavior. That is true of the leadership. That is true of the career staff at the Antitrust Division. They believe in the principle to undergird the antitrust laws and want to enforce those laws for the common good. They reject the silver cup of temptation to betray the law for personal gain. Sadly, there are other people inside and outside of government who offer and accept the silver cup and who care little for the antitrust laws. They consider law enforcement not as binding rules, but as an opportunity to leverage power and extract concessions. They have, shall we say, a loose relationship with the law. It goes without saying that the most senior law enforcement officials in the United States should care deeply about the rule of law. They should know the law and follow it, and they should not punish those who defend it. And now, the hardest part of my speech is how much I can say. So I'm going to say very little, but I hope you underline the amount of information behind what I'm saying in this paragraph. Although I'm limited in what I can say, it is my opinion that in the HPE Juniper merger scandal, Chad Mizell and Stanley Woodward perverted justice and acted inconsistent with the rule of law. I'm not given to hyperbole, and I do not say these kinds of things lightly. As part of the forthcoming Tunney Act, it would be helpful for the court to clarify the substance and the process by which the settlement was reached. Although the Tunney Act has rarely served its intended purpose, this time the court may demand extensive discovery and examine the surprising truth of what happened. I hope that the court blocks the HPE Juniper merger, and if you knew what I knew, you would hope so too. Someday, I may have the opportunity to say more. The second distinction between the rule of law and the rule of lobbyists is that those who follow the rule of law show no special favors to the parties and counsel appearing before them. By contrast, the rule of lobbyists cares deeply about the benefits they can extract in transactional relationships with perceived friends. At the Antitrust Division, we routinely have lawyers that appear before us whom we know and respect, But I'll be honest, we also meet with lawyers who are unethical scoundrels and malcontents, the kind who game the system and crow about it. We ignore the affiliations of these lawyers, whether friend or foe, Republican or Democrat, and attempt to treat everyone equally. That's how we maintain one tier of justice and restore the integrity of the DOJ. Others at the DOJ and elsewhere in government consider some parties, counsel, and lobbyists to be on the, quote, same MAGA team, close quote, and therefore worthy of special solicitude. They consider others to be, quote, enemies of MAGA that merit particular disfavor. In my opinion, based on regular meetings with him, Chad Mizell accepts party meetings and makes key decisions depending upon whether the request or the information comes from a MAGA friend. Aware of this injustice, companies are hiring lawyers and influence peddlers to bolster their MAGA credentials and pervert traditional law enforcement. Third, the rule of law provides predictability while the rule of lobbyists guarantees instability. Violations of antitrust laws impose grave risks to companies, including criminal prosecution, massive civil penalties, company breakups, and the blocking of mergers. Lawyers and their clients need a stable and predictable environment to do business. The Antitrust Division uniformly seeks to promote the rule of law in both litigation and merger enforcement. I personally have heard lawyers say that the political uncertainty of this administration is more difficult than the predictable but hostile environment of the Biden administration. I should emphasize that I welcome all lawful competition and all pro-competitive mergers. Before recent events, the original topic of my talk today was in praise of little tech innovation and pro-competitive mergers. Nor is there anything wrong with lobbying if it's done the right way. But this new pay-to-play approach is so far removed from legitimate lobbying or traditional antitrust enforcement that it is creating massive legal and economic uncertainty. Those adopting this new approach care little about the instability this creates in the markets. The cost to the country of this new pay-to-play approach to antitrust enforcement is enormous. For 30 pieces of silver, MAGA in name only lobbyists are influencing their allies within the DOJ and risking President Trump's populist conservative agenda. This goes far beyond traditional lobbying. Their goal is to line their pockets by working for any corporation that will pay top dollar to settle antitrust cases on the cheap. Doing so undermines the rule of law and desperately harms the average American. At risk are President Trump's antitrust goals of reforming healthcare, addressing monopoly abuse, promoting deregulation, and helping renters, farmers, and blue-collar workers. Is this the new normal? Will every law firm hire an influence peddler to dual track and sidestep the litigation and merger review process? Is that what law firms are now doing? The Department of Justice is now overwhelmed with lobbyists with little antitrust experience, going above the Antitrust Division leadership, seeking special favors with warm hugs. On numerous occasions, in a variety of matters, we implored our superiors, and we implored the lawyers on the other side to call off the jackals, but to no avail. Today, cases are being resolved based on political connections, not the legal merits. Which case is the next casualty? Will the same senior DOJ officials ignore the president's executive order just because Live Nation and Ticketmaster have paid a bevy of cozy MAGA friends to roam the halls of the fifth floor in defense of their monopoly abuses? I wonder what the national security argument will be in that case. What must the antitrust bar think? If the new game in town is to hire well-connected lobbyists ignorant of the law to get your deal done based on case, and get your case dismissed by going above AAG Slater, what role are respected, ethical antitrust lawyers and economists supposed to play? Why did the lawyers advising the parties in these cases, in the HB Juniper case, not appreciate the risks that they were generating, not only for their clients, but their law firms and the entire antitrust bar? Lastly, there are real costs for the lobbyists, the companies, the lawyers, and the government officials who listen to them. Their reputations are forever linked to the unethical behavior. Mike Davis and Arthur Schwartz have made a Faustian bargain of trading on relationships with powerful people to reportedly earn million-dollar success fees for helping corporations undermine Trump's antitrust agenda, hurt working-class Americans, break the rules, and then try to cover it up. Outside the small circle of transactional MAGA friends seeking and giving favors, do these lobbyists and their friends in power actually know what traditional or populist conservatives think about them? When lobbyists like Mike Davis and Will Levy go to their Supreme Court clerkship reunions, how do honorable conservative lawyers who clerked for the great Justices Alito and Gorsuch view their shenanigans? Do the executives and the lawyers who hire these lobbyists know what the antitrust bar, know what the division's leadership, know what the lawyers at the DOJ think about their behavior? They have long memories. Those who forsake the rule of law are violating fundamental moral principles. Quote, a just king gives a country stability, but one who demands bribes destroys it, Proverbs 29. You shall not pervert justice. You shall not show partiality. Justice, and only justice, you shall follow, Deuteronomy 16. A wicked man receives a bribe in secret to pervert the ways of justice, Proverbs 17. Do not show partiality in judging. Hear both the small and great alike, Deuteronomy 1. I know many in government and out of government who sincerely respect these moral principles. Perhaps now is the time to implement them. The influence peddlers and allies in government will hide behind their friends in power, excuse their behavior, claim that we are being naive, and hope this all goes away. But many of their friends in power have principles and want to avoid further scandal. How will the Department of Justice recover from the current crisis that it's in? Will there be policy or personnel changes among the senior leadership of the Department of Justice? Will Gail Slater have the freedom to enforce the law and free to hire and fire her deputies consistent with the administration's true antitrust agenda? At a minimum, will the Department of Justice remove the compromised Chad Mizell and Stanley Woodward from any antitrust oversight and have Gail Slater report directly to Todd Blanche? In the absence of reforms at the DOJ, must state AGs now join every DOJ antitrust lawsuit and merger challenge as a check on influence peddling? The status quo is simply unsustainable. I'm in my final page now. When I began my service at the DOJ, I swore a solemn oath to well and faithfully discharge the duties of my office. What will be done when senior DOJ officials betray their oath? What will be done to a nominee who has already shown that he cannot be trusted to honor such an oath? And now let me conclude with a personal reflection. President Roosevelt was one of the great antitrust reformers, and lately I've been thinking a lot about his famous speech, The Man in the Arena. Quote, and I think you probably all know this, quote, credit belongs to the man who's actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes up short again and again, because there is no effort without error and shortcoming, but who does actually strive to do the deeds, who knows great enthusiasms, the great devotions, who spends himself in a worthy cause, who at the best knows in the end the triumph of high achievement, and who at the worst, if he fails, at least he failed while daring greatly. In my first tour of duty at the DOJ, I love that quote because I could relate to the triumph of high achievement as Macon Delrahim and I successfully negotiated an agreement on fundamental due process signed by over 70 countries. In my second tour of duty, I love that quote for what it says about failing while daring greatly. My position while I served in government was simple. Lobbyists and lawyers are subordinate to the law. Yet by stating this truth, I was dismissed for insubordination. My termination letter is now framed and hangs on the wall at Notre Dame. I joke with friends that I've never been fired before, and I've been working a long time. My first job was as a young teenager at the Dairy Queen in Sherman, Texas. All it took to be fired were lobbyists exerting influence on my superiors to retaliate against me for protecting the rule of law against the rule of lobbyists. A final thought on the subject of taking risks to serve our country in these difficult times. Is it really worth leaving the Shire to battle the orcs? On both occasions that I was offered a senior position within the DOJ, I was told I shouldn't accept the offer. The risks are just too great. For me, that wasn't a sufficient reason. I knew that I would be attacked. I know that I'll be attacked today. I knew it would be difficult. But I also know that the rule of law is not just an inheritance, it's an obligation, an opportunity. Soldiers are willing to go to war to risk their lives to serve our country. So why shouldn't we take lesser risks to serve our country and protect the rule of law? The principles inscribed in marble at the Department of Justice survive each generation only if they take up the fight. Failure is always a possibility, but so too is triumph. I would rather fail while daring greatly than not serve at all. Thank you.
Thank you. Thank you. Thank you very much for that, Roger. I'm going to ask one question and then open it up. Am I correct in interpret that you think the best way to resolve this is a full Tunney Act proceeding that reveals exactly what went on, or is there a better? Yeah, I think it's that one.
Yes.
Well, you like.
Yes, I think.
Alan?
Yes,
But
I think that would be ideal.
Yeah. We should hand out the, yeah.
Thank you, Professor Alford, for your candor and your standing up for principle. I wonder, though, whether you could put your perspective on the transgression of the rule of law in this antitrust context in the battle between lobbyists and the rule of law in the broader context of the disposition toward the rule of law in the administration generally and the Department of Justice specifically. Some might think that in light of the general approach to the rule of law in the Justice Department and in the administration, that it would be surprising to be surprised by the violation of the rule of law, right? I mean, we have the dismissal of the criminal charges against the mayor of New York, and that resulted in numerous prosecutors of great reputation to resign or to be dismissed. We've got executive orders against law firms that numerous judges have said was brazenly unconstitutional, egregious violations of the rule of law. I mean, it seems to be that violating the rule of law is kind of par for the course. So maybe if you could put your surprise and disappointment at the violation of the rule of law in the merger scandal in the greater context of the Department of Justice and the administration more generally. Thank you.
Yeah, I mean, obviously, I want to be careful about what I say. I think that some of the decisions that have been made with regard to what you're talking about are done as a matter of principle, where they take a certain position about executive branch authority and they want to test the limits of what those are. And so, for example, I personally think that the reason that the various commissioners in the various independent agencies have been fired is because they want to test whether or not Humphrey's executor is still good law. And so, in my mind, they needed some test cases in order to determine whether or not that was the case. And so, with respect to some of the other issues, I just want to be really careful about what I say, because I want my remarks, which were intended as a friend of the administration, to be corrected and hopefully, taken in good faith. And so, if I'm overly critical, then there will be pushback in that regard. So I'm just going to be careful.
We have time for one more question. Yes, sir.
Here we go. Hi, Josh Cisco with Bloomberg News. There was another recent, it wasn't a settlement, it was a dismissal, full sale dismissal of a merger case. And I'm wondering if you think that was done to avoid the court review process. Because if you pull up lobbying forms, there's Trump-affiliated lobbyists with those companies as well. And then also more broadly, what do you think the chances are of these reforms actually being enacted? Thanks.
Oh, I think that the possibility of reform is very significant. This is not a systemic problem. This is a personnel problem, and I think there are leaders that could be removed and leaders that could be uplifted, and we could solve this problem. So I wouldn't be speaking out and taking risks if I didn't think that there was a possibility for reform. The veiled references in my speech suggested that lobbying campaigns applied in a whole variety of different cases, and that the one you're referencing was one of them. That's public information. And that one is a more complicated case because there really were legitimate failing firm defenses. The firm was slowly spiraling downward into just basically bankruptcy. And so it's a much harder case than the one I just referenced today. And then the other thing I would emphasize is that a lot of the settlements that have been happening have been really good settlements. I don't want to suggest that there haven't been good settlements. And that was before what's happened last month and since what's happened last month. And so I'm not saying that this is going to happen in every case and that there might not be some success, but it unnerves me how many lobbyists have been hired on how many different cases and for what reason. Why are they doing that? I can't tell you how many times we said to the lawyers, can you just deal with us on the merits? Don't go above our heads with lobbyists. So that's unnerving. So.
Okay, thanks very much,
Thank you.
Roger.